Today we will talk about the preventive and punitive detention. So, firstly, why news and why we are talking about the punitive and preventive detention. So, what happened actually? Recently the Supreme Court gave a judgment on the preventive detention, which is case related to the Banka Ravikant versus the Tamil Nadu police and related to the preventive detention, which comes under Article 22 of the Constitution of India, consists of fundamental right part 3rd, and that's why we are talking about. So what is the case? What happened that actually the Tamil Nadu police arrested in the September 2020 a man which has actually got the anticipatory bail in the 5 criminal cases. So if that doesn't satisfy, then the Tamil Nadu police actually arrested that man under the preventive detention law. So that's why actually the wife of this man, means the Banka Ravikant, the wife of this man actually went to the Supreme Court, and then the judgment came related to the preventive detention. So we will talk about what is the judgment and what is the main significance of the judgment related to the preventive detention. But firstly, we have to talk about the what is preventive detention, punitive detention, what comes under Article 2020, and what are the actually the laws, famous laws. And as you know, related a UP doctor case is also related to the preventive detention, very famous, or actually got the bail from the actually Supreme Court. So this is all about. So we will also talk about. So firstly, we will discuss what is under article. There is a preventive and punitive detentions, and then we will talk about the what is the judgment of the Supreme Court. So under Article 22, remember that this is under Article 22 comes under the right to freedom, and under Article 22 there is a protection against arrest and detention. It consists of 2 clauses. Firstly, the punitive detention and the preventive detention. So remember that punitive detention deals with the ordinary laws of the country. So whatever is the ordinary law for the arrest, detention, conviction, trial, whatever is the ordinary law. So this is talk about, so that comes under the ordinary law. So preventive detention deals actually with the preventive detention. Very famous National Security Act 1980, and which actually applied on the UP doctor, very famous doctor, and that's why and got the bail after the Supreme Court judgment. So this is actually deals with the preventive detention law. What happened in the punitive? In the punitive, what happened? Why punitive detention? Here what happened, if someone has the criminal act or civil act, then they are arrested. But in the preventive, because they will commit something, they will commit some crime in the near future which can affect the public order, law and order, and that's why this person is arrested without any trial and conviction. This is one of the very important difference between the punitive and preventive detention. Another is what happened that in the punitive detention, what happened, it is the right to be informed the ground of detention. Means, suppose if someone is arrested by the police, then under the punitive detention, means whatever the under the ordinary law, if they are arrested, then the person has the right why I have the arrested by the police, or why I am arrested by the police. So this is all about. But under the preventive detention law, no such requirement, means even the reason need not to be given ki why you have arrested by the police. And another is the detention of 3 months has been given. So what happened under the preventive detention law? There is the committee formed, and which committee actually consists of Judge of High Court, and actually that said that ki yes, this is under the preventive and this is the necessary requirement actually to arrest the person, because it is either the danger to the law and order or public order, and that's why I need to arrest that under the preventive detention. So after that committee actually arrested the under the preventive detention, but that detention will be for the 3 months, and after the 3 months, then they have to take the permission of that board which is constituted by the particular state government or either of the central government, basically the district magistrate. Now we will also talk about what are the further provisions comes under the punitive and preventive detention. Now other parameters actually which differentiate the punitive and preventive detention. So what happened here is that the right to consult and be defended by a legal practitioner, means the offender or whatever the offender under the punitive detention they have the right to consult by a legal or by either as an advocate, or they have to be right actually to defended by a legal practitioner. Even actually government provided the advocate to defend in the court. So this is all about. So here what happened in the preventive detention, after the 3 months what happened, grounds of detention can be communicated with the detainee. So whatever is the offender under the preventive detention law, the ground of detention can be communicated. But if there is any apprehension danger to the public order, that in one ground cannot be communicated with the detainee. So this is another difference between the preventive and punitive differences. Another is the right to be produced before a magistrate within the 24 hours. So whatever under the punitive detention, they have the right to be produced before a magistrate within 24 hours. But here happened, you know, there are the some cases like the UP doctor recently this is, so you can consider that September 2020. So that case what we are talking about, the Banka Ravi Khan, September 2020, and we are today August, around yesterday, the 4 days ago actually the judgment came. So you can say that here around 1 year. So even 1 year they can be detention can be take place, but the minimum detention time is the 3 months. So irrespective of everything, you know, you need not to produce before a magistrate either in the court anything. At least 3 months you have to spend in jail if you are arrested under the preventive detention law. After that, the advisory committee will which consists of the judges of high court will check you, and if the further you will be arrested or under the jail under the preventive detention law. So this is all about, unless and until that is around the 6 month is at least to be the, and then it will go to the high court, and if high court actually gave a judgment, then it went to the Supreme Court. So this takes around the 8th-9th month at least. So here no such requirement to produce before a magistrate within the 24 hours. So this is all about. Another is the opportunity, but yes, if there is a something related to in high court went to the matter, or if there is a in the advisory committee, the opportunity to represent against the detention. So offenders has the opportunity to represent itself by an advocate or either itself against the detention kiosk. This is not the actually the ground which I have been arrested by the police. So this is all about. Another what differentiate that this punitive detention actually only available to the citizen. So this right is only under the punitive detention only available to the citizen. But this preventive rights actually comes under both the citizen as well as the aliens. Aliens, those who are the enemy nations or those who are not basically the particular country or not basically the Indian citizen. Remember that if we talk about the punitive detention, obviously the laws, public order, law and order actually comes under the state government. So laws made by the basically the state government. But under the preventive detention law, both the state and union, means the state and central government can make laws, and obviously they have made it. So National Security Act is very famous preventive detention law actually made by the union government. So this is very obviously a state can make also, like the Gujarat has made it. So this is all about. We have talked about so far why we are talking about the punitive and preventive detention. What actually basic difference between the punitive and preventive detention, that here is the under the preventive detention actually the arrest can take place without any trial and conviction, and that would be for 3 months without any communication, without any before presenting before a court advisory board or even in the before the magistrate. And under the punitive detention, if there is any ordinary law, and this is under the preventive detention can only be arrested under the preventive detention law. But in the punitive detention, what happened that actually by any ordinary law made by the state government or union government, or if any person found guilty, then will be arrested. But it will be after trial and conviction, means the full-fledged procedure under the criminal code of criminal procedure will take place, and that why, and after that the conviction will take place of the person. So this is basically a simple which is given a right to the ordinary people. So this is all about. Another that here is the right to inform, right to consult, right to be defended by a legal practitioner. So this is all about, and even produced. But here is the no such requirement for at least the 3 months. After that the communication take place and even arrested, rearrested, and then it actually went to the Supreme Court and then the High Court and the Supreme Court, etc. can take place, and this is all about. So this we have talked about. So now we will talk about what is the actually SC judgment comes under the preventive detention law, which is the very important judgment, and subjective kind of question can be asked on the basis of that. Now let's talk about the judgment of the Supreme Court which came recently related to the preventive detention. So firstly, the Supreme Court, while dealing with this case related to the Banka Ravi Kant and versus the Tamil Nadu police, so what happened? The first said the preventive detention is a necessary evil to prevent the public disorder. So what happened that, what is do you mean by the necessary evil? So necessary means it is the requirement, means the requirement actually when there is a apprehension danger to the law and order or either the public disorder or any harm to the public disorder, then it is necessary. But what the state government or union government actually do, that's why it becomes evil. So that's why it becomes evil. So what it actually use the person actually to crush the liberty of the people, and that's why it is an evil. So it is a necessary evil. So without the preventive detention the work cannot be done, but it is evil because it actually crush or life the liberty of the people, and that's why it is evil. So what Supreme Court that preventive detention is a necessary evil only to prevent the public disorder. So this should be used only when there is apprehension danger to the public disorder, and that's why, and so otherwise in not other cases there should be a preventive detention. Another word Supreme Court said that while giving the direction to the state, said that the state should not arbitrarily resort to the preventive detention to deal with the sundry law and order problem. So what happened that, what actually a state gave direction that, so suppose if there is any problem related to the law and order, suppose if a car driver actually driving the car with drink, so this is not a public disorder, it is a kind of law and order problem, and that can be something can be taken place. But in such cases what that you cannot impose on a person in the preventive detention law. So this is a kind of law and order problem. So what Supreme Court said that ki state cannot arbitrarily use, means you cannot use in a very vague manner this preventive detention law. Another word said that the court must ask while dealing with such cases that ordinary law of the land sufficient to deal with the cases. As I have told you, if there is any car driver actually driving the car with drinking, then that is a law and order problem, that is not the preventive detention. So it is actually giving the direction to the court as well. Suppose that because every cases went firstly to the district court, not directly came under the Supreme Court. So that's why while dealing with such cases, firstly every court have to check that this whatever the crime has been take place, this can be done either by the ordinary law of the land, or if that would be found legal, then the preventive detention should be declared as illegal. So this is actually giving direction to the court. Another that preventive detention must fall within the four corners of Article 21 due process of law, and read with the Article 21. As I have told you, what is deal with the Article 21? The Article 21 is the right to life, protection against the arrest and detention. So that's we are talking about the Article 22. So this should be, here is the right to life should be protected, and that right to life should be read with the Article 22, means in the Article 22 there is a protection against arrest and detention is also prevail. So this right should be afforded because the individual liberty our freedom fighters has learned after many years of struggle, actually get after the many years of struggle, or if there is any harm to that individual liberty, that would be undermine the constitutional or whatever the forefathers dream. So that's why what Supreme Court said. So this is the very significant judgment, because as you know there is the heavy imposition of the preventive detention law, either the terrorism law or anything like that is going on the country. So that's why this judgment is very significant judgment, and obviously there are some judgment will came like this. So this is all about. So what we have talked about so far, what is the case, why this case we are talking about preventive detention. Remember that preventive detention and punitive detention both deal with the Article 22. Article 22 what? Protection against the arrest and detention both. So what we have talked about what is the differences between the punitive and the preventive detention. what is the main famous preventive detention law? You can say the National Security Act 1980. So this is all about. What is the Supreme Court judgment? The most important word is here the necessary evil, and is this necessary evil is just like a delegated legislation. So this is what the Supreme Court judgment. So this is all about. We have talked about the preventive detention. Thank you guys. Hope you like this video. You should subscribe my channel. Thank you so much for watching this video.